The American green card waiting time has always been a little infamous for being exceptionally long, with applications taking more than decades to be processed. However, recently there have been some changes or updates that have created potential opportunities for people who applied employment-based green card under certain categories. But this is also creating a little havoc for people who have been waiting in the line for, a few years now. So let's review these changes and the impact it will have. In order to get an American green card, you must be eligible under a certain category. You can apply your green card under the family category or employer, or through a special immigrant category like a religious worker, or you can also apply under victim status. Now, today in this video, we will talk about the employer-based green card. And there are 5 types of employer-based green card. So the first is EB1, which is for exceptionally skilled people like researchers or Nobel Prize winners. Then comes EB2, which is for skilled workers with advanced degree or with, a minimum of 5 years of experience and a bachelor's degree. Then comes EB3, which is for people with bachelor's degree or any kind of specific training. Then comes EB4, which is again for special immigrants. Say somebody has worked in Iraq as a translator with the US Armed Forces, so that person will be filed under this EB4 category. And then the last category, which is EB5, is for investors. Mostly, if not always, an employer who files an H-1B for its employee can also file a green card under employment-based category for that same employee, under EB2 or EB3 category. And that's why these are the most crowded categories, where the wait time is more than 10 years. Most specifically, I think for EB2 it is 10 to 11 years, and for EB3 it is 12 to 13 years. Now, for a very long time, the notion was that an Indian can get his or her green card faster under the EB2 category, which is the higher preference category, compared to EB3 category. And therefore, it was also not very uncommon for an EB3 applicant to put their green card under the EB2 category once they complete their masters in the US. Now, while we expect this to continue to be the case, experts have most recently seen a little change in the trend, with EB3 cutoff dates advancing and becoming more favorable than the EB2 cutoff dates. So in the October visa bulletin, the final action date, which is the actual wait time for EB3 category, is January 2010, and for EB2 it is September 2009. While this may not seem like a really significant difference, the real advantage comes for the final action date, which is what DOS expects to be available in the coming months for them to manage the workload, which is May 2011 for EB2, and I think it is January 2015 for EB3, meaning an Indian applicant in the EB3 category will get the green card 3.5 years faster than the one in the EB2 category, which is kind of a really unique situation. And you can ask why the low preference category, which is EB3 compared to EB2, will have a shorter wait time. And I guess the only logical explanation of that is when there are more applicants filing green card under a certain category from a specific country, then the visas are available for that year, then I think the backlog creates. Over the last several years, the initial EB3 applicants have been able to upgrade their cases to EB2 category and hence joining the EB2 wait time. And the new applicants eligible for the EB2 category have also applied in the EB2 category and hence joining the same rate line again, which has increased the demand in the EB2 category and hence created backlogs. At the same time, the demand in the EB3 category has not gone up that much, and that's why the dates are advancing much faster in the EB3 category to use the number of visas available in that category. And for this reason, many people want to downgrade from EB2 to EB3, which is absolutely possible given your employer is ready to do that, because it is a little expensive process. But you should also consider the fact that as many EB2 applicants will downgrade their cases and file under EB3, it can again increase the demand in the EB3 category, which may ultimately slow down the processing time. So you should really weigh your risks and benefits by talking to an attorney, of course. But say if there are 75,000 applicants in the EB2 category who downgrade their cases to EB3 category, then the final action date in the EB2 category could move to 2013. So I guess the choice is really clear there, that if you are in the EB2 category and if your priority date is after 2013, you may get a little benefit by downgrading your case, as you can file for the adjustment of status, which is I-485. But if your priority date is already before 2013, then there is a little risk also. So that's why I think I would consider counseling with an attorney on the next steps. So thank you so much for watching the video and stay tuned.